Hello everyone and welcome to the program. I'm Shewa Kimbaloye in Lagos. During the 2015 election campaigns, one thing was predominant in what General Buhari of the APC said he wants to pursue when he wins the election, and that is to fight corruption. Because according to him, he said at that time we must kill corruption before corruption kills Nigeria. And when he assumed office on the 29th of May 2015, he wasn't dilly-dallying on that. He was clear on his mission and his plans to fight corruption. But along the line, it does look like a lot has gone wrong in getting the job done. Just in the past week or so, about 4 major cases was lost by the federal government and some of his prosecuting agencies. Tonight on the program, we assess the anti-corruption war of the President Buhari government and how far it has gone. Some say it's just media trial. Some say it's corruption fighting, but other people saying it is just a witch hunt in all of these. Well, what do you make of it? Why don't you go on to Twitter and several of our social media platforms and let's get talking on this one. Joining me to take a look at this issue is the Senior Special Assistant to the President on Prosecution, Chief Okoye Obono-Obla, joins us from our Abuja studio. Many thanks for coming on the program. Let me start by asking you, what do you make of the cases, major ones, that was lost, 4 of them, or 3 major ones, I should say, in the last week?
I'm glad you corrected yourself. 4 major cases were not lost. There is a misconception there. The case against Urubebe and some engineers in the Ministry of Niger Delta Affairs was not lost. That case was withdrawn by virtue of the fact that the Attorney General of the Federation, who is the Chief Law Officer, has the power to discontinue any case pending in any court of law in Nigeria in respect of an offense created by an act of the National Assembly. So in pursuant to the powers vested on the Attorney General of the Federation, that case was discontinued in public interest in order to prevent abuse of the court process, in order, in the interest of justice. That is what the provisions of Section 174 talks about of the Constitution. So that case was not lost. The case of the wife of the former president, Mrs. Jonathan, well, that case was the motion to vacate the order freezing the account of Mrs. Jonathan containing about $5 million. The motion was vacated because the judge said the EFCC did not file a counter affidavit to challenge the motion filed by the lawyer to Mrs. Jonathan, Ademola, SAN. So then the case of Ademola, Justice Ademola, his wife, and Agi, SAN. Well, it is part of the legal system. What we saw, we have a court of trial, we have the court of appeal, we have the Supreme Court, and you have the right to pursue your matter right from the trial court to the Supreme Court. The Office of the Attorney General of the Federation has filed a notice of appeal. 3 notices of appeal were filed on Friday in reaction to that judgment, which we consider perverse, strange, absurd, to say the least, because the learned trial judge delivered a judgment rather than a ruling on the no-case submission that was made by the defendants. And he went ahead, evaluated evidence, ascribed evidential value to the evidence he evaluated, which was not supposed to be the case. What the judge was supposed to answer was, did the prosecution made out a prima facie case to warrant him calling upon the defenders to explain. And he went on a voyage. He went on to give a judgment. And I can mention more than 500 legal authorities that says the judge at that level, he cannot go into the merit of the matter. He cannot evaluate evidence. He was just supposed to answer a simple question. Let me give you an example. The judge heard that Section 60 of the ICPC Act did not apply. That is not the position of the law. It applied fully. If you look at the facts of the matter, the judge was alleged to have collected gratification from the senior advocate of Nigeria. The money was paid into his account, 30 million naira. And if you read Section 60 of the ICPC Act very well, it applies. It applies fully because that section says evidence shall not be admissible to show that the gift was in respect of a trade or a vacation on a social location and so forth and so on. Then the other one about firearms, 2 firearms were recovered from the judge on the 7th of October 2015. And the licenses had expired as far back as December 2015. During trial and during cross-examination, a document was tendered, 2 licenses were tendered through the weakness of the prosecution by the counsel to the defendants. But those licenses were wrongly dated by the judge, 12 October 2000. But the point I'm making here is that the judge now used those 2 new licenses that were issued after the arrest of the judge to say that under the Firearms Act, the intent of the Firearms Act is that the defendant should be given reasonable time to produce a license, that because of that, the defect has been cured. That is an absurd ruling.
All right.
So,
let me
talk about the other matter concerning.
All right. You've explained some of these cases. And what we come, I've allowed you to do that because, of course, you needed to give the background to some of the worries of many Nigerians on some of these cases. Because in 1 week, we saw all of these judgments happen, and it's not in the favor of the federal government. How would you assess the prosecution from the federal government's point of view this time around and the prosecuting agencies on some of the cases so far? Would you say that the federal government, since 2015, that the president has set out to fight corruption, has been successful?